have your cameras turned off and yourselves muted, please. That would be brilliant.
2 seconds. I'm just listening to.
We'll just give it another 30 seconds for everyone to join. Brilliant. So I think we'll get started. Hello everyone and welcome to the SEND National Trial webinar for local areas. Just as I mentioned at the start, if I could please get you all to mute yourselves just to stop the feedback and to turn your cameras off so we can see who our presenters are today, that would be brilliant. Great, thanks everyone. So my name is Holly Sallard. I work for Mott MacDonald and I'm delivering this webinar for you today on behalf of the DFE with my colleague Emma Bird. So before we go through the agenda and start to introduce our presenters, I just wanted to inform you all of a few IT housekeeping and Teams etiquette rules for the webinar today. As you'll see, there's quite a few of us on the call, which is brilliant. So I firstly want to mention that today's webinar is being recorded and it will be uploaded to our online toolkit after the webinar takes place. So for the duration of the webinar, could we, as I've mentioned before, please keep yourselves muted and your videos turned off. Presenters will have their videos on whilst they're speaking in the session, so it'll be clear to us who's presenting what. If you are struggling with Wi-Fi connection, you'll see a couple of simple instructions here on the screen. So we'd suggest that you turn off your incoming video and you can just do that by clicking the 3 dots and going down to the drop down that says turn off incoming video. And this can help with if you've got bad Wi-Fi connection. So the panel Q&A, which is taking place at the end of the webinar, will be going through all questions that are posted in the chat box. We won't be taking any verbal questions in today's webinar because of the amount of people that are joining us today. It's just much easier for us to manage that by the chat function. My colleague Emma will be managing these questions and will prioritise these by the number of likes a question has. So if you would like a question to be answered, if you just hover over the question in the chat box and give it a thumbs up, and that will make the process easier for Emma. If you don't have the chat option, this may be because you've joined the call as a guest on Teams. So I'd suggest that to get that chat function, you leave the call, log into your Teams account and rejoin. So just a bit of Teams etiquette for today. So number one, please do participate in the Q&A at the end of today's session. We have some fantastic speakers on the webinar today, so please do make the most of their wealth of knowledge on the national trial. Number two, if you do have multiple questions, it's easier if you post one per chat message, just so we can monitor those coming through. Also, as I mentioned, please do like other people's questions if you'd like it answered to give us an idea of how to prioritise those questions. And lastly, please be aware of duplicating any questions as well, just so we're not going through the same ones. Perfect. So on to the agenda now. As I mentioned, we have some fantastic speakers with us today to share their knowledge and experience. So I've given you a quick introduction to myself and my colleague Emma at the start. So I'm next going to be passing on to Andre Imich from the DFE, who's going to give us an overview of the SEND National Trial. We'll then move on to a session on mediation, which is delivered by Susanna Deagle and Audrey Dorival from Kids Mediation Provider. And we also have the pleasure of welcoming 2 SEND colleagues, Marion and Karen, today to speak about the benefits of mediation from a SEND perspective, which is fantastic. So then after that session, we'll hand over to Doug Easton from HMCTS, and he's going to run you through a session on how to prepare for a hearing. And then lastly, as I've mentioned as well, we'll be ending the webinar with a Q&A panel session where you all as attendees have the opportunity to ask questions to our knowledgeable presenters on any of the sessions that they've ran today. So without further ado, I'll hand you over to Andre.
Thank you, Holly. Just to introduce myself, Andre Imich. I'm the SEN and Disability Professional Advisor in the department. It's good to see a number of names there that I recognise, so hello to you all and hello to everyone else. It's great that there are so many people here today and the numbers keep on rising, I can tell. And what's also good about today's attendance is that you seem to be an audience that cover a wide range of really relevant areas that are involved in the redress appeals. So we've got representatives from local authorities, we've got health colleagues, particularly CCG colleagues, we've got some parents here. So a really important and wide range of people. So I just want to give a basic overview of what the trial is about, what the basic rules are. But first, let me start with just going through some of the data. We've had a publication by about the data on the latest position regarding numbers of appeals. And I think without actually going into much,
Oh, we seem to have lost Andres there. We'll give him a few seconds to just rejoin. Just while we wait for Andre to rejoin, could I just remind you all to please mute yourselves and keep your cameras turned off, just for the ease of the presenters? That'd be brilliant. Thank you. Just seeing if we can get Andre back. There we go. Hi, Andre. Can you hear us okay?
I can. Can you hear me?
Yes, we can. I think it just cut off there. It might be your connection, but
no, it's not. I must have said something that one of you disagreed with already, and you cut me out and kicked me out. Well, I'm back. I'm back.
Brilliant. Thanks, Andre.
Right. So hopefully that won't happen again. Whoever it was, don't do it again. As I was saying, there's obviously been quite an increase. I don't need to go through that data. My next slide will pick that up. But you can see there's an ever increasing number of appeals, which is probably why we've got so many people here today to try and understand the high level of activity and what we're learning. This is a graph about all appeals, including those that have gone to the redress system. Next slide, please, Holly. So this is a little bit more detail on the recently published data. So it's almost 8,000 appeals in one year to the tribunal. That's an increase of 13%. That actually mirrors pretty much the increase in last year's numbers of EHC plans, new EHC plans issued, which was an increase of about 10.5% on the year before. So 10.5%, 13%. There does seem to be some sort of correlation there. Of all appeals to the tribunal, almost 3 in 10 are about refusal to do an assessment on request. That's a fairly standard figure since the reforms, and before that, the high number against refusal to assess. Of the remainder, 58% were in relation to the content of plans. We know that almost half of all appeals have something to do with autistic spectrum disorders. So in a way, that's important intelligence for those managing casework, that cases that you're involved with that involve autism have a higher possibility of parents making an appeal. So I think that's an interesting learning in terms of the way cases are managed. Turning to the trial itself, just over 1,000 of the 8,000 were appeals under the trial. That's in 1 year. That's not since the trial began, but in just 1 year. And that's an increase from the previous year of 900, which was 908. That should say an increase from 908. And there you have the breakdown of that 1,100 cases. So the majority, 589, were about appeals to about both health and social care. Smaller numbers of single appeals about each of those two areas. Slides, Holly. So let's remind ourselves of what this trial is about. The single route of redress. Before the trial began, appeals could only be made about the education aspects of education, health and care plans. So if there were concerns by families or young people about health or social care, they had to be dealt with through separate redress systems. But now a parent or a young person can appeal about all the aspects of the education, health and care plan. And under the trial, the tribunal is now empowered to make non-binding recommendations. Come back to that in a minute, but always as part of an appeal about education aspects. The trial has actually, it was started for just 2 years. It's been extended until the 31st of August next year, so another 8.5 months to go. The reason for the extension is largely down to the need to make sure that we've got robust evaluation data. So I'll say a bit more about that shortly. Slide. Next slide. So the key aims, what were we intending to do? To create a much more holistic, person-centered view of the child or young person's needs. This is very much in line with the sort of central ethos of the reforms, to create a single perspective and bring, and what we wanted to do with this was to bring the rights of redress in line with the wider remit of plans. So we brought all the single elements of needs and provision together in the reforms through the plans, and what we then subsequently wanted to do was bring redress about those together. We also felt it might further encourage the joint working expectations of the Act between local authorities. And remember, when I mention local authorities, I am talking about the education or the SEN services and social partners in this regard, and health bodies. And we also wanted to explore whether this extended right would become a permanent right of appeal. So whether we needed to change statutory primary legislation on that front. Next slide. So to meet those aims, we developed a number of features. So the tribunal has got wider powers, can make non-binding recommendations. They're not statutorily, local authorities or health are not statutorily obliged to follow recommendations. I'll come back to that again. Unlike education, which must follow the orders of a tribunal about special educational aspects of a plan. It applies to all local authorities and CCGs in England, but in order for an appeal to be made, there does need to be an appeal about the special educational aspects of the plan. So there must be a concern from the family or the young person about a special educational element of the plan, and then adding in a further concern about health and or social care. We've also asked Ofsted and CQC, when they're back firing on all 4 cylinders again, to be considering this as part of their wider local area in SEND inspections. We also have an ongoing evaluation team looking at that, looking at the whole issue. They're looking at the implementation processes. What does it mean in terms of the demands on local authorities and health? Go back a bit. And all the agencies involved. So what are the implementation issues there? What are the outcomes on families and agencies? How has it affected their lives and their working requirements as well? And of course, we also need to consider the economic and cost data about the process itself and the outcomes generated. There's an independent evaluation team that's been involved really since the start, looking at all those 3 areas. There's currently quite a big piece of work going on the economic and cost data. And if any of you on this call, on this webinar, are approached by them to engage, we would be pleased if you could say yes, so that we get a much deeper understanding of the impact in terms of cost and economics. Thank you. Next slide. So what types of appeal? Just I'm sure that most of you know this, so I'll go through this very quickly. The appeals can be about almost anything to do with decisions made around an education, health and care plan, except for that initial decision about the decision to assess. Remember, I said at the beginning with the data that the decision to assess or not is the highest area of appeal. About 30% of all appeals to the tribunal are about the decision to assess. So that's not part of the redress, because the statutory criteria in terms of that decision is only about a child's special needs and their possible need for additional special educational provision. It isn't about health or social care needs or provision. Of course, people can still appeal against the refusal to assess, and we know that 30% of all appeals are about that. As I've said, you must have, parents or young people must have an educational complaint in order to make an appeal. And interestingly, the tribunal has the power to include or add education. If they're dealing with an education-only appeal, they do have the power under these regs to consider health and or social care aspects should they become apparent and relevant during the appeal process. Next slide. I'm not going to read these out. They're there. You will be getting the slides probably very soon. But just a reminder of those, the range of decisions that can be appealed as part of the trial. Holly, next slide. So when a tribunal makes recommendations, what happens? Well, within 5 weeks of the recommendations being made, health and or social care bodies, depending which party the recommendations fall to, must write to the family and to the local authority, to the SEN team that's managing the case, within 5 weeks to tell them if they're going to follow the recommendations. If they are, then they need to explain what they're going to do, but if they decide not to, they need to give a detailed explanation as to why they're not following the tribunal's recommendations. In these instances, parents or young people can take the case to the Ombudsman or the judicial review. And it raises all sorts of interesting issues because the tribunal is a body made up of legal and professional experts who have taken account of all sorts of evidence in reaching their recommendations. So that would be an interesting area if it happens. So that's what must happen. There must be good consideration of any of the outcomes, the recommendations from the tribunal, and there must be communication with families within 5 weeks. Next slide. So what are the limitations for the trial, of the trial? Well, it's one obvious limitation is that it is only possible to appeal when there is an educational aspect and concern. So it has to be driven by educational concerns and then adding on health and social care. Obviously, the issue is about, there'll be issues and considerations about that fact that I've mentioned a few times. The recommendations are non-binding. The law does not require health and social care to follow the recommendations as it does for education services who must follow the orders of a tribunal. So that's obviously a major issue in terms of limitations. But we do say that although the recommendations are non-binding, they can't be rejected lightly. They've been made by an expert body, and it would, of course, be interesting if there were ombudsman or judicial review consideration of all of that. Final slide. The benefits are those that we're in our aims really to try to bring together all the aspects of a plan so that redress is a much more straightforward issue. All the elements can be reviewed in one place. It's a one-stop shop. Now, those last two slides, the limitations and the benefits, we're likely to be able to populate a lot more once the evaluation is concluded, because they are looking in detail at the limitations and the benefits and making sure that we have an evidence-based approach to understanding the limitations and the benefits. And all of that through the evaluation team and their research will contribute to recommendations made to ministers in both the DFE and Department of Health and Social Care next year about the continuity, or whether to make this a permanent feature of the statutory framework. So that's an introduction to the national trial. I will be here for the Q&A at the end, so do feel free to raise queries or to post them on the chat. Thank you. Holly.
Brilliant. Thank you very much, Andre, for that session. That was a brilliant overview. So next on our agenda, we've got the session on mediation. So as I'd mentioned, this is being delivered by Regional SEND Manager Susanna Deagle and SEND Mediation Manager Audrey Dorival from Kids Mediation Provider. And we also have the benefit of having our two SENDIAS colleagues on the call, Marion and Karen. So over to you all.
Thank you.
Good morning, everybody, and thank you, Holly and Emma, for inviting us to speak about SEND mediation. My name is Susanna, and I'm here with my colleague Audrey to talk about special educational needs and disability mediation. I'll give you a very brief background about kids. We are a national charity, and we're working with the age range 0 to 25, offering a full range of services for children with special educational needs and disability and their families. One of the services we provide is SEND mediation. This year is our 50th anniversary, Kids' 50th anniversary. And as you might see from the first slide, which we can't see at the moment, but we are also the winner of the National SEND Mediation Award 2020. Audrey and I will take turns to talk you through this presentation. So can we stay on this slide, please? So what we shall cover today, our aim today is to give you a very, very brief overview of how SEND mediation can be used as an alternative to the tribunal process. We're going to look at the role of the local authority and health professionals in the mediation process. We're going to specifically look at benefits, but also at some what we call top tips and advice for preparation for a mediation and taking part. If you need more detailed information, you can look at the Kids website, or you can obviously contact us directly. Kids also provide a range of training modules that relate to all aspects of SEND mediation delivery. Next slide, Audrey, please.
Thank you. So I'm Audrey Dorival and I'm Kids SEND Mediation Manager. So let's look at what exactly is SEND mediation. How might it differ from your more typical local meeting? Well, it's a structured child, young person centred process that takes place before an appeal is lodged. You have a mediator who's impartial and independent, who is there to help the parties work together to agree solutions to their dispute. It isn't the mediator who makes the decision, it's the participants. It's confidential, flexible and informal, so it feels very different to tribunal, but it is tightly structured. It can be arranged quickly and there is very little paperwork involved. So there are no mediation bundles, for example. At the end of the discussion, the mediator helps the parties to draw up an agreement in their own words that is what we call a SMART agreement. And what do we mean by that? It is specific, it is measurable, it is achievable, realistic, and it contains timescales. So everyone knows who has to do what and by when. It helps to reduce stress, time, costs and other resources by de-escalating matters and promoting resolution early. And finally, and this is really, really important, what many of you out there will be aware of and have experienced yourself is that with these SEND disputes, there can often be relationship breakdown between the local authority, clinical commissioning groups and families. There can be a history of challenging or difficult communication. What mediation does is it improves relationships and it promotes positive communication. When you think about the fact that the relationship in this SEND context can be from 0 to 25 years old, that's birth to 25, the relationship is so important. Next slide, please. Very quickly, for those of you who want to find out more in terms of the statutory framework for mediation, we've put this slide in and directed you to Chapter 11 in the SEND Code of Practice, which sets the framework out, and also the SEND Regulations 2014, which set out the law around mediation and disagreement resolution. Two final points to note for this slide. Local authority attendance is mandatory when families have requested mediation, and also the local authority representative that attends must have decision-making power. Next slide, please. Susanna.
Thank you, Audrey. Just a quick look at the typical disputes that would come to SEND mediation. So they all fall under the education, health and care plan process. The only thing I would like to add to this slide is the important difference that you can go to mediation for disputes about health and care elements of the final plan only. It does not need to include the educational element. So that's different to when people wish to make a tribunal appeal. Next slide, please. Quick look at who might be involved in mediation. There are key people, the parties, and then there are others that might take part. So obviously the parent carers. Wherever possible, we would like to have the child and young person, specifically if they're over 16 years old, because as you know, if they're over 16, the law applies to them directly. So at KIDS, we make a huge effort to bring the voice of the child into the meeting in some way or another, whatever is possible. The local authority will be there, or health services, and also social care if it's the local authority. And then often in 99% of cases, somebody from the education provider. And of course, the mediator. Others might be a range of professionals. So for example, somebody from SALT, speech and language therapy, occupational therapy. Then there are supporters, and the supporters can be for both parties. We're not just talking about supporters for the family. Local authority officers, education providers also sometimes feel it makes it easier to be in a meeting when they have somebody at their side. Typically, you would have 4 to 5 people in a mediation. Next slide, Audrey.
One of the commonly held myths or understandings out there is that parents have to take part in mediation. That's not correct. What the requirement is to consider mediation. And so families have to take part in what we call a mediation information and advice session, sometimes shortened to the word MIAS. So the local authority decision letter must include details on how to contact a mediation provider. If it doesn't include the mediation notice, that letter is defective. The family must contact the provider within 2 months from the local authority decision letter. And the MIAS usually takes place on the telephone. And one of the key points to be aware of is that the MIAS must be non-biased, neutral, and must not push families towards mediation. And as a result of the MIAS, the family has a chance to ask all their questions and become fully informed about what mediation is. As a matter of good practice, we always check whether the family have contacted their local SEND-IAS, because it's really important that the family have access to good quality information and advice. And finally, if the family decide they don't want to take part in mediation, that's absolutely fine. We will issue them with a certificate, a mediation certificate, and they can use that if they decide they want to go on to tribunal. They put it with their tribunal appeal. Next slide, please, Susanna.
Thank you, Audrey. Quick recap of the mediator's role. They need to be specialist mediators. They need to understand the SEND context. That is important for them to be able to gain the trust of the family and the professionals they work with. So all your SEND mediators should be accredited under the new DFE supported SEND mediator standards. Just something to look out for when you commission as well. The mediator is there to facilitate the meeting and keep a strong focus on the child and young person and the disagreement to be resolved. And that is a really important role, because mediation meetings in kids are about 2 hours long, so the focus needs to be maintained. To be able to work with high emotions is another aspect of the mediator's role. For example, if you have a dispute where somehow it has turned into a personality clash, or where there's a very, very long history of things that the family feel have not gone right, it's really useful to have an impartial mediator to help with that. And sometimes you get into deadlock trying to find solutions. Again, mediators are trained to ask a number of what-if questions to move things forward. Audrey has already spoken about the SMART agreements, so we make sure they're specific, measured, achievable, realistic, and time-bound to ensure they're easy to follow. Next slide, Audrey.
So we've been specialising in SEND mediation for almost 20 years. And what we wanted to do is share some of our experience with you in terms of top tips for when you are preparing for a mediation, so that you feel really confident and comfortable in that space. Firstly, respond to the mediation service promptly once the request for mediation has been made. This can really help to de-escalate matters. If you're not the person who has case managed the case, then consult with colleagues who do know the case. Have a look at the original decision. If you decide it should be reversed, do so promptly. Again, that helps to de-escalate matters and promote early resolution. Know the law and apply it. And ensure that you have full decision-making authority on the day. And I'll come back to that. Next slide, please. The next tip is think about who should attend the mediation. So it's all about preparation, preparation, preparation. Do you think you might need someone there from health or social care, someone from the school, or maybe another professional, the educational psychologist? Obviously, we don't want the mediation to be unmanageable with hordes of people there, but we need to think about who are the key people that need to be around that decision-making table. And as early as possible, contact the education provider and any other parties to find out whether there's any key or new information that you should be aware of. That will save time and that will make for a much more productive mediation session. Susanna's already mentioned the child and young person's views. Getting the voice of the young person into the mediation process is vital. At Kids, we have spent many years working directly with young people, so we have a range of methods for doing this. And that's something you must think about Are the child or young person's views known? Sometimes the young person will attend the mediation, maybe for all or part of it. Other times we might have a recording or some other way of getting their views into the process. Prepare a brief summary of the issues from your perspective, be you local authority or clinical commissioning group. This really helps you to order your thoughts and think about what you want to say, so you'll feel more confident in yourself. Next slide, please. And the final top tips. Plan what you can bring to the mediation session, including any broad parameters around what you can or cannot agree. Have a think about that in advance. If needed, perhaps arrange for a senior colleague to be available at the end of the telephone. It may be that your decision-making authority goes so far, but beyond that, you would need to check in with a more senior colleague. You can perhaps have them at the end of the telephone, and that way the mediation can proceed seamlessly. And finally, and this is again very important, if you're new to SEND mediation, be you from a local authority or a clinical commissioning group, let us know. We have resources. We can provide additional information, support and training. So just let us know so we can ensure that you are really feeling confident when you enter that mediation. Next slide, please, Susanna.
Right, I'm aware of the time. My Swissness is coming out here, so we're going to try and hurry through the final slides. Top tips at the mediation meeting. Really listen to what others have to say and show specifically that you've heard and understood. You can do this by body language as well as, asking then reasonable and interested follow-on questions. You can show empathy even if you do not agree with other people's viewpoints. And be really curious. Ask these open questions so that you, as one of our mediators calls it, you can really bring the child out of the file. Next slide, please. Thank you. Don't be defensive. You may not have made the decision, neither the healthcare professional nor the local authority representative. It's usually have been a panel. The mediator will explain at the start of the meeting that you are not the decision maker. So it allows you to encourage different views rather than trying to defend a decision. But the one thing that's hugely helpful is that second bullet. Be prepared to fully explain your decision and how it's been arrived at. That massively helps in mediations. Audrey and I, we both are also practicing mediators, so we know that this is something that really works. And the final point is, because we have smart agreements that are easy to follow through, please follow them through promptly. The mediation has helped you gain the trust or regain a level of trust from the family and the others involved. So following with the actions promptly helps maintain that trust. Next slide, please. Next slide, please.
It's there, Susanna.
Should be just
it's there now. Thank you.
Yes.
So if you want a resolution process that's quick, informal, and working together, and also has the aim of improving communication, then you really need to consider to use mediation more and make it well known within your local authority. Next slide, Audrey.
Very briefly, so we're bang on time. Some key stats and data to share with you. 85% of the mediations result in full and partial agreement. 97% of mediation participants reported to us over the last 12 months that they were either satisfied or highly satisfied with our service. And to give you a sense of scale, we deliver about 1,000 mediations a year. I just want to end with one piece of data that came out with the SEND Tribunal stats last week. which showed that 5% of local authority decisions are upheld at tribunal, which gives us a really pause for thought in terms of the whole dispute resolution framework and use of mediation. I would now like to pass over to Karen Edwards and Marion Deely, our SEND advisors, who very kindly agreed to join us today. Holly, you're showing some slides that people can have a look at a bit later, which are just sort of testimonials from education, health and social care. But I'd like to pass over to Marion and Karen. Thank you.
Hello, it's Marion here. I'm just to give you a brief overview. I'm from Peterborough, which is a small local authority, unitary authority, and where Karen comes from a much larger authority. So we're given the aspect from two different local authorities here. We have in Peterborough a very, very good working relationship with kids mediation. We have open dialogue with them. And I think that from a SEND point of view really helps parents engage in mediation. The other thing that we do in Peterborough is we offer, as a SEND service, we offer to support parents at all mediations. So the offer is there. It's up to them whether they want us to be present. 99% of our parents do take up that offer. But again, I think that encourages parents to take up that view of mediation first to see if they can get things resolved. And because we then have that very good relationship with the kids mediation company and also the individual mediators, I think that helps to put parents more at ease and engage in the process. We also have quarterly meetings with our kids, with Susanna, who runs the kids contract from our side, and we've had open dialogue with them about how to improve the actual mediation process for parents, and from both a local authority point of view, a SEND point of view, and from a mediator's point of view. And this has improved, I feel this has improved this service and been readily available for the parents. The other thing that we do as a SEND service, and I see there's lots of comments in the chat, but we encourage parents to use mediation rather than use tribunal. And we encourage them to use that process as their first way of going through things, and if it then cannot be agreed or the outcome isn't what the parents wanted, they still have the right to go on to tribunal. But we wholly encourage for all areas, including dispute resolution for naming of placements as well. And in the main, we have the take up is greatly taken in Peterborough from parents to go through that process. I will now hand over to Karen.
Thank you very much to all of you. I'm the manager, as I've already been introduced, of the SEND service in Hertfordshire, which is very much a larger local authority. Excuse me. I'm also the contract holder for the mediation and dispute resolution service, and like Marion, have very much been excuse me, involved in the development of the service, which is invaluable. But I wanted to spend a little bit of time just sort of sharing some from our perspective in Hertfordshire, the value and importance of mediation for families that we work very closely with. As a service, we support families to explore the potential value and benefits of the mediation process, and some of that includes you know, that really vital opportunity to meet face to face, or obviously more recently it's been virtually. And that's often for the first time. So where people have talked previously about relationships and conflict, whilst it can be quite a worrying process to engage with, actually the outcomes are often really outweigh sort of their fears in the first place. And it enables the families to share their concerns, add clarity, and to give further detail, which is often really difficult for them to do and to express through paperwork. It provides a really safe, and some of this has been talked about previously, but to reiterate, it provides a safe and open forum for each of the parties to have that opportunity to, you know, really listen to each other without interruption and hold those open conversations. And the meetings are facilitated by really skilled and experienced facilitators, and they take the time. I think what's invaluable is to take the time to speak to the parties. In particular, can you hear me?
Yes.
Yes, we can hear you.
Yes, yes.
Sorry,
Yes.
I thought somebody was saying they couldn't. Sorry. And they take the time to speak to the parties, in particular parents, beforehand, and talk them through the process and explain what that's going to look like. And I think that really helps to improve confidence and offers reassurance. And during the meetings, we've found, as we attend many of the mediation sessions, but we find that the mediators actually then hone in and explore some of those key areas. When decision makers from the local authority attend the meetings, it really enables positive outcomes to be reached. If not on some of the areas, often it can be with regards to all of the issues. And I think the process provides the opportunity for everyone to work together, to have that really holistic approach and to explore options together. I mean, for example, a recent situation that we attended was where there was a refusal to issue an EHC plan following an assessment. The local authority wrote to the parent to provide an opportunity to meet face to face with the family at a early sort of resolution meeting. And despite that option being taken up, no resolution was reached on that day. So the family chose to request a mediation meeting. And feedback from the parents afterwards was that was a really positive opportunity. So despite the fact they had met with the local authority previously and it had become quite difficult, actually this provided the opportunity for them to be able to sort of share further information. But in fact, the school attended, and it was also an opportunity for the local authority to hear really clearly from the school that actually they were providing so much more over and above quality first teaching. There was an outcome reached on the day, and the local authority agreed to issue an EHC plan. I just wanted to very briefly, because I know I've got a minute to go, but I wanted to give you some feedback in Hertfordshire, because I look at the quarterly reports, and the parents and the local authorities' feedback is actually very high. So one parent reported this allowed my opinion to be voiced. Everyone seemed to be working for my daughter's best interest at the centre of all the discussions. And the local authority said that it allows an open and honest discussion for all of the issues and allows clarity. And in fact, recent feedback showed that 100% of parents agreed or strongly agreed that they felt mediation helped to resolve the areas of disagreement. And I suppose finally, I can't stress enough the value and importance of mediation, as it helps parties to reach that earlier resolution. This can result, of course, in better outcomes, and it helps families to avoid unnecessary applications to the tribunal, which can be a really stressful process and doesn't often allow for those open conversations. And it provides a vital opportunity again for the families to be able to communicate openly with those working with their child or young person. Thank you.
Brilliant. Thank you so much to Susanna, Audrey, Marion and Karen. It is brilliant to hear, all of those great feedbacks that you've all had from mediation and the benefits it can bring to everyone involved. So on to our third session, to today's webinar. I'm going to pass you over to Doug Easton from HMCTS, who's going to deliver this session on how to prepare for tribunal. So over to you, Doug.
Yes, hi. Normally this session would have been taken by Jason Greenwood, who's the sort of delivery manager for the SEND Tribunal in Darlington. He's unfortunately unable to make the session today, so he's asked me to step in as a late replacement. Now, I work for the jurisdictional support team within HMCTS, which supports the HESC chamber. So my duties cover sort of mental health tribunals, special educational needs, care standards, and primary health lists. Now, this session is going to cover the sort of role of witnesses and how to prepare a tribunal bundle. Now, the role of the witness, quite obviously, is to provide evidence to the tribunal of the child or young person. The guidance on how to prepare a bundle we'll talk about in a bit more detail shortly, but what we'll cover is what the bundle will should actually cover, the evidence that's got to be submitted, how to prepare a bundle, and what sort of deadlines are involved in that. Normally, the tribunal bundle is submitted about 15 to 20 days before the hearing. Now, I should maybe mention at this point that there's actually going to be a change in the listing process. Currently, the date of hearing for any appeal is sent out when the appeal is first registered. So it's sent out without any consultation at all with the parties. We're introducing a new process in January, where the local authorities and the parents will be asked to identify within a specific dates period, say for example a month, 3 dates that are mutually convenient to both of them. So this step we think will reduce the number of cases that are actually postponed because parties aren't available on the dates that we have specified initially. So could I have the next slide, please, Holly? Thanks. So you'll find, I should possibly say that you'll find over the next course of slides that there's an awful lot of words that you can read later. But the witnesses should be familiar with the child or young person, and it's up to each party to bring along the witnesses who will give the tribunal a clear picture of the child's needs. So next slide, please, Holly. This slide talks about expert witnesses. And an expert witness is somebody who essentially has a specialist knowledge in their field of work and can answer questions on the child's or young person issues, the level of attainment and so forth. You will note that they don't have to be medically qualified or scientifically qualified. I'm not quite sure what the scientifically qualified part means. Next slide, please, Holly. Thank you. So an expert witness, as I said, can be an educational psychologist, speech and language therapist, or a SENCO. They must be somebody who has dealt with a child or young person, and based on the information that they have gathered, be able to make conclusions about the child or the young person. Now, if the expert witness can't attend the tribunal hearing in person, now whether this is a virtual hearing or a face-to-face hearing, the report can be submitted as evidence within the tribunal bundle. Now, obviously, it's preferable that the expert witness does attend, as this will allow the tribunal to ask questions and clarify any concerns or issues they have about the report that's been submitted. So next slide, please, Holly. So we're now going to look at how to prepare a tribunal bundle. The tribunal bundle is required for all appeals that go to a hearing. Now, guidance has been issued which explains what's actually got to be included, but in essence, it's all of the documents sent to the tribunal within the deadline set, which should actually be included. No other documents or reports should be added to the bundle unless they've been formally submitted to the tribunal and copied to the parent or the young person, again within the timescales that have been submitted. It's important to remember that the local authority who has responsibility for preparing the bundle can't decide whether a document or a report should be included in the bundle or not. The simple approach to take is that everything that's been sent in by the parent or by a young person should actually be included. And failure to send the bundle in time can actually lead to the local authority being barred from the proceedings because of its failure to comply with a tribunal direction. And it's not in the interests of the tribunal not to have both parties present. Because of restrictions to the size of emails that we receive when bundles are sent in electronically, it's meant that local authorities often have to split the bundle into several emails. Now, we've recently introduced what's called a document upload centre, which we're now offering to local authorities to use. So instead of splitting the bundle into several emails due to the size limits of mailboxes, local authorities can now upload one file of up to 500 megabytes onto a secure area of e-judiciary platform. For more information on how to access this document upload centre, or if you want to use the document upload centre in future, send your request into send@justice.gov.uk. Next slide, please, Holly. So looking at preparing the actual bundle itself, if you're submitting a bundle, right, by post, please ensure that all the documents are photocopies and not originals. Only one copy of each document should be included. So, for example, if a parent has submitted the educational health and care plan, there's no need for the local authority to include, in effect, their copy of the health education and care plan if it's exactly the same version. So this will reduce the bundle size. There are page limits, and these are provided on the guidance on the gov.uk. Right, next slide, please, Holly. Thanks. Now, what to include in the tribunal bundle continued. Now, each tribunal bundle should include an index to show what's included in the bundle. So when at the hearing, when the parties refer to a particular page, everybody can navigate through the bundle together. If the tribunal bundle that's submitted by the local authority doesn't include an index or the pages are unnumbered, it will be returned to the local authority for in effect correction. This will failure to do this will actually prolong the hearing if we've got to sort of flick through the various pages and everything else trying to identify the appropriate page. Right, and next slide, Holly. So this is what to include in the tribunal bundle. So obviously you have the notice of appeal form, response, local authority, decision letter, requests for changes, all tribunal changes, all tribunal directions, the attendance forms and submissions. and the EHC plan. This should include all appendices listed in section K of the plan if necessary. And next slide, please, Holly. So I'll continue on with this. The local authority evidence would include letters, emails, policies, written records, information from the school file, witness statements, school or college prospectus, the school SEND information report, Ofsted report and details of costs of educational placements and so forth. These are the documents that are often seen in tribunal bundles, but the list is not exhaustive, and it's up to each party to deem what evidence they rely upon that they're going to produce as evidence at the tribunal to include that in the bundle itself. Next slide, please, Holly. Now, the working document. The working document is needed in all appeals relating to the content of the EHCP. This shows the tribunal what has been agreed and what remains disputed. Now, if further changes have been made to the working document prior to the hearing and after the bundle has been submitted, that again must be sent to the tribunal. Now, at the moment with virtual hearings, it should be emailed to the tribunal's mailbox. When we return to face-to-face hearings, in these circumstances, you must bring along 5 copies of the document to the tribunal hearing itself, because obviously the venues we use, there's very, very rarely any photocopying facilities available. And next slide, please, Holly. Again, this is just talks about the deadline for producing the bundle itself. And if we move on to the final page, this is places where you can actually get more information. So these are the useful pages in gov.uk, along with a YouTube video of how to come to a hearing. And just a very, very brief reminder, the staff in SEND can only give procedural advice. So they can't give case-specific advice or tell you what documents to lodge or what you should do. If parties require legal advice, obviously they should seek their own. So that's me. I finished 5 minutes early. Back to you, Holly.
Brilliant. Thank you very much, Doug. And just for everyone's reference, the webinar recording will be uploaded. So if you do want to go back to any of the information that any of our speakers have covered, you can do so when that has been uploaded. So we're now going to move on to our panel Q&A session. And I'm going to hand over to my colleague Emma, but just quickly before we do that, I'm going to put a link to a short feedback form in the chat box. So we'd be really, really grateful if you could all fill that out. It will literally take 2 minutes or so, just to know how your experience has been on the webinar today. So we have about 25 minutes for the Q&A session today. And as I mentioned at the start, if we could please continue to keep our cameras off and our mics muted and manage all the questions via the chat box, that would be great. So I'll hand over to you, Emma.
Thank you, and thanks again to all of our speakers today, and thank you also for your contributions in the chat. I've been collecting some of the questions as they've been coming through the chat box. If you have any more, please feel free to add. If we don't get a chance to go through everybody's questions, we will be collecting them all, and we will be sharing advice on those questions that we can't answer in the time we have in our communication after the event. I'm also conscious that Doug is stepping in for Jason, which we appreciate at short notice. So if there are questions that we can't answer today, similarly, we will take those away and we can respond in our follow-up emails. So Doug, seeing as your session was last, I have one question just to kick things off. And the question is, do all expert witnesses need to provide a witness statement? As this person has found that there's been a bit of mixed advice. Is this something that you could give a bit more information on?
That I don't know, right? But we can find out for you, and obviously we'll come back to you with the correct answer.
Fantastic. And I think this question, the one other question that's was raised in regards to evidence, I think you might have covered this, but it was a query around the size of evidence submitted. So if the local authority was to receive, for example, extensive evidence from a family, is there a limit to how big these documents should be?
Yeah, this is set out on gov.uk. There is a separate guidance been issued on what should be or the size of bundles. Yeah, but it's on gov.uk anyway. But I can provide a link to that guidance.
Fantastic. Thanks very much, Doug. So a couple of questions on mediation for either Susanna or Audrey. The first question was, what should local authorities be expecting from mediation from the mediator providers ahead of the sessions, so that the local authority has the information they need in advance of the meetings?
Audrey, shall I take that one? I can't hear Audrey, so I shall take that one. It's Susanna here. It depends on your provider. So kids have a model where we put a lot of work into the preparation for the meeting, and that also helps to keep the meetings shorter, which is specifically important now that they are virtual. So you all know a very long virtual meeting is very tiring and needs a lot of focus. So we have what we call mediation summaries that the mediator prepares or the caseworker prepares with parties, and they are wherever possible shared before the mediation meeting so that there is clarity of the agenda and clarity of what parties wish to achieve in the mediation meeting. Other providers may have different ways of providing that information. I hope that answers that question.
Thanks, Susanna.
I'll just add to that, if I could. I'll just add to that that if the person who asked the question is aware of who their own provider is, if it is us, then please contact us afterwards, and we can talk people through in more detail about things.
Fantastic. Thanks for that offer, Audrey. Follow-up question. Somebody has made a comment saying that in the past they've been told that they can't take notes in mediation. Is that correct?
I'm happy to take that one, Susanna. We would not say to any participant that they mustn't take any notes. What the mediator will say is that any notes the mediator takes, they will destroy afterwards. They will shred those notes because they'll have no future involvement in the case. But in terms of practical matters, people do make jot-ins and notes as they go along to remind themselves of what the issues are and what they might want to say. Susanna, I don't know if you have any further thoughts on that.
Yeah, could I also add, I think this has come from it's sort of the pure mediation aspect that you shouldn't take notes because it's confidential what is said during the meeting, and certainly we wouldn't expect people to make minutes of who says what. However, we do not say you can't take notes. It's important that you can. It helps you if you want to remind yourself of a question. And what we have instead is we have a pre-mediation agreement form that clearly sets out the confidentiality aspects. So everybody who takes part in mediation has got to sign that, has got to tick the confidentiality box. So it's clear that whatever notes are taken are for the meeting only, so to help you through the meeting.
Fantastic. Thank you both. And one final question on the mediation. I think there's as you've probably seen in the chats, conversation around wanting or to encourage more people to consider mediation rather than going straight to tribunal. Any advice that you could provide people attending today on how to encourage more people to think about it?
Audrey, if I start this off, I think reflecting back to what Marion and Karen have said from the SENDiAS, that is really the first step, clarity about what the service offers and support from both the local authority and the local SENDiAS to engage with the process. However, it's also absolutely crucial, and that's something that we looked at in our presentation, that when the local authority comes to mediation, A, they provide dates quickly, and B, they come with full decision-making power. If that doesn't happen, then families will go away thinking, well, what was that about? Was that worth the effort? And that then obviously, as we all know, word of mouth is quickly spread, and you then have local authorities or local areas where there may be parental groups that say, don't bother with mediation, you know, you may as well go to tribunal. Audrey, do you wish to add to that?
Yes, I wanted to rethink, encourage people to think strategically about this. So have people from your mediation provider come to your parent carer forums, for example, to raise awareness, because often people don't want to engage with something that they don't know a huge amount about. So alongside everything that Susanna has said, I would also actively encourage you to get mediation providers at your parent carer forums and other parent group meetings to really, you know, answer any questions that parents might have about the process to build confidence and trust in the process.
Thanks both, that's really useful practical advice. I do actually have one more question on the mediation. It is a bit broad, but I think we've got a lot of health colleagues attending today, and it would be useful to know a little bit more about the role of health in the mediation process. I think particularly around the decision-making aspects of the mediation.
Right. So the key thing for those from health who are attending today, and I notice there's very many, which is great. The key thing is that you only have to attend mediation. So it's compulsory for you if there is a final plan, and if within that final plan there is a disagreement about the health provision. So that's your sections G. And otherwise, you may be invited to attend mediation as an expert professional, but that again depends on what arrangements you have made with the local authority. For example, within kids, there are some local authorities who want to be informed as soon as a health need is clarified, and we would then contact the DCO and say there is a health issue, would you want to take part in mediation? That's how we would go about it. Audrey, have you got to add?
Just to add the point about the strategic approach, which is that we do run bespoke training. We provide bespoke training for clinical commissioning groups for health providers around mediation, because again, it's something that they are perhaps less familiar with than their local authority colleagues. So, you know, contact us or contact your mediation provider to find out more about bespoke training that we can provide.
Fantastic. Thanks very much. That was the last one on mediation. So I'll move on to some more general ones. I would, I suppose, just caution is there's quite a few comments and questions that come out that I think would require specifically a response from SEND Tribunal. So Andre, I'm going to run some of these questions past you, but I'm conscious that that not all of them will be able to answer. But just to start off with one question around the refusal to assess that you mentioned in your slides. Do we have any information or do we have the data that gives a percentage of the 29% of refusal to assess appeals that are then overturned at tribunal? Or is
no,
that data available?
The actual outcomes from individual appeal systems isn't available, but I think I posted saying that of that 30%, about 90% do not get resolved by the tribunal. They get dealt with through conceding it or it being withdrawn. So presumably when when an appeal is made, local authorities are reviewing the evidence with their families and reaching an agreement on the best way forward. It's only about 10% of those appeals that get dealt with by the tribunal, but we don't, going back to the question of those 10%, we don't have the data on which way they go.
Fantastic. And as Andre mentioned in his opening slides, HMCTS have launched some data this week. We will include the link in our follow-up email so that you have access to that. Okay, I had a question around, and again, Andre, forgive me if this is outside of your scope, around conflicting advice that's provided to tribunals from different providers. I know you touched on this in the chat, but it would be good just to follow up. In your opinion, how are tribunals managing that conflicting when they're receiving those conflicting advice?
Yeah. I mean, obviously, I can't speak for the tribunal and how they manage their case decisions and so on. But I do think we all, in dealing with that, we need to recognise that all the time, local authorities and CCGs are in receipt as part of everyday casework of conflicting advice. You're dealing with that on a daily basis. How do you deal with it? Because I suspect the answer you give will be very similar to what the tribunal give. There is conflicting advice on a number of children's cases. Nobody knows the exact percentage, but there is conflicting advice. It's something that's part of the system, and you're dealing with it every day. How does the tribunal deal with it? I suspect they would give exactly the same answer that you give. I know it's a tough one, and I'm not trying to belittle it, but it's something that challenges us all.
Thanks, Andre. I'm just looking at the other questions that we are receiving, and many of them are similarly are best answered by the SEND Tribunal. What I would like to just highlight to those attending is that we'll be holding a series of national events in February and March, which will have a presentation and a Q&A session from a SEND Tribunal judge, who is best placed to be able to answer some of these questions. So those invites will be going out in the new year, and the events are specifically for DMOs, local areas, SENDIAS, and social care teams. So keep an eye out for those invites when they come through in the new year, and the questions that you've asked regarding the SEND Tribunal, and that would be a fantastic forum for you to be able to get clarity on those areas. I'm going to just share a couple others. Andre, please feel free to let me know if they're best answered by the SEND Tribunal. So I've got one question around the use of privately commissioned assessments, which are becoming increasingly more common. Do you have is there anything that you could share in terms of the increased use on those and how they're being dealt with at the moment?
What's the actual question, Emma?
Well, I suppose the question is around where I suppose it's the conflicting advice again, where there's a private commissioned report versus one commissioned by the local authority or the health provider, and if more weight is carried.
And again, I'm aware of the great sensitivity around this. One would again reflect back to normal local authority and CCG situations, because you deal with an awful lot of cases that don't go to appeal, that don't go to mediation, where there is conflicting advice and where parents do submit private reports. I'm hoping that your answer would be, on every case where there is private reports, we always consider what the private therapist or psychologist has to say. We always consider that and weigh it in the balance of all the evidence we are receiving about that child's needs and difficulties, and end up with a view that has taken account of that private report, as well as the many other reports that we have commissioned through the local authority health and social care. So it has to be, you have to consider it, and then you have to make your own story built on that evidence and every other piece of evidence. So that would be my sort of response at a purist level. I know it's a highly emotive subject, particularly when it gets to the tribunal. But again, I would go back to my earlier answer. This is day-to-day stuff.
Fantastic. Thanks, Andre. If there are any other questions, please feel free to add them to the meeting chat. The remaining, we have a few more minutes left. So feel free if there's anything else that you'd like to know on any of the topics that we've already covered. As I mentioned, there are a few topics that have been discussed in the chat that are much more specific to SEND Tribunal and the judges. So please let us know if you're not already subscribed to our quarterly newsletter. Please email us. Holly, if you wouldn't mind adding our email address to the chat, that would be fantastic. And that way you'll have first notification of the dates in the new year. Also, just to let you know that at Mott MacDonald, we host a helpline email service. So if you have any queries relating to the national trial, please make use. It's the same email that Holly has just posted. So that's senddeliverysupport@mottmac.com. We also have a wealth of resources in our online toolkit for health colleagues and local areas, and that includes templates, sample letters. We collect all of the queries that we get through our helpline, and we produce an FAQ document, so you might find some of your answers in that document. We also have useful guides, fact sheets. We've got one very popular one, which is a children and young people's guide to making a complaint, which we co-produced with key stakeholder groups. So do have a look. We'll share the link to that website in our follow-up email. I don't think I'm getting any more questions, so I think we'll close today. Holly, is there anything else if I hand back to you?
Yeah, no, just a big thank you again to all of our presenters and to everyone who's joined us today to watch this webinar. We hope you found it really useful and you've got some key nuggets of information from it. I've just put the survey into the chat box again, just the quick 4-question survey that would be really grateful if you could fill out. So thank you again all for attending and hope you have a lovely rest of your day.
Thank you, Holly and Emma. Thank you.
Thank you.
Thanks, all.